in the light of the recent judgment that has been passed by the Apex Court. By this discussion, we will try to understand the intricacies and the integrity of the judgment and its implications. I am your host today, Chaitanya. I am joined with my co-host, Khalil Rahman. I am a third-year law student at Campus Law Center. Khalilur Rahman is a law student from Karnataka State Law University. I'll briefly introduce Najar to you. The National Alliance for Justice, Accountability and Rights, aka Najar, is an initiative of the National Alliance of People's Movement, collectivizing progressive legal professionals for democratic causes and solidarity with the people's movement across the country. Najar has been conceptualized as a united and vital platform for A, practicing lawyers, B, law researchers, C, law faculty, D, law students, and E, law graduates involved in the social legal activism. Today, we are joined by three esteemed panelists, first of which is Arvind Narayan, who is a lawyer and writer based in Bangalore. He is also visiting faculty in the School of Policy and Governance, Azim Premji University. Then we are joined by um, Rais Mohammed, a former assistant professor in Madras University and a postdoctoral fellow who worked in the University of Southampton, South Africa. He is also the founder of Dalit Camera. Next, we are joined by Dr. Ashna. She is an assistant professor at NLS Bangalore. She researches on the prevention of atrocities law and teaches an elective course called Reading Ambedkar on Caste and Law. Let's begin with and this will be moderated by our moderator, Naveen Gautam. Over to you, Naveen.
Thank you, Chaitanya. I would like to introduce myself. I'm Naveen Gautam. I'm a lawyer. I'm a researcher, and I'm presently working with an organization known as Global Forum of Communities Discriminated on Work and Decent, and also keep trying to give more time on different aspects of advocacy, capacity building, research, and other aspects. Let's kind of quickly. I'll give you the background of how we are moving forward to the discussion, and we have so many speakers, and of course the term which I forgot to mention is which I always mention whenever I start my discussion, which gives me strength, is of course Jai Bhim and Jai Samvidhan. And as Chaitanya has already mentioned, it's great to be here to discuss a highly, deeply significant issue that has, to some extent, shaped India's long struggle for social justice, the whole question of reservation, and of course, the debate around which has been reignited by this judgment, that is subclassification within the scheduled castes. And of course, giving the background of the judgment in the state of Punjab and others versus Davinder Singh. The debate on subclassification, it has been reignited, different forums, different organizations, different civil society organizations, different political parties have different versions, how it is, it is supposed to be or it was supposed to be. And there are, of course, those who argue that subclassification is essential to ensure that the benefits of reservation actually reaches to the most who are in need of. And those subcastes that have remained marginalized even within the larger enigma of scheduled caste categories. And on the other hand, there are those who fear that this move could kind of, dilute the collective identity of Dalits and to some extent the Adivasis, weakening their whole united struggle, which they have been trying to strengthen since past many years against the historical injustices. And of course, to some extent, opening the door to political manipulation. That's another version which most of the groups which are kind of opposing this judgment. But very specifically, the Supreme Court has pointed out committee reports such as Justice Sadashiv Committee report and Justice Ramachandran Raju Commission report, and that has evidences. It's not like Supreme Court which is saying this thing, which I'm very sure Arvind will also take forward this discussion. It's not Supreme Court which is saying it's there are evidences and many other organizations. If you look at the whole data of National Campaign on Dalit Human Rights, we look at the whole data of Martin McCone, Dalit activists who are kind of ensuring that they have very strong data. So, to strengthen the Dalit communities, undermine the struggle for social justice. So there is a whole discussion through which I'm very sure will come through this next 1 hour of discussion which we are kind of following. And मतलब मेरे हिसाब से मुझे लगता है बहुत जरूरी है इस चीज पे चर्चा कर सकें, जिसने कुछ हद तक भारत के सामाजिक न्याय की एक लंबी लड़ाई को आकार दिया है। आरक्षण से जुड़े मुद्दे कहीं ना कहीं किसी ना किसी रूप से आते रहते हैं, और कभी हम आरक्षण को जातिगत हिंसा से जोड़ देते हैं, कभी उपवर्गीकरण के बारे में बात करते हैं। तो इस पे हम थोड़ी सी चर्चा करेंगे, और I'll try to kind of translate things in Hindi also while I go forward in English. But as I mentioned earlier, there is also a political angle involved in this, and of course the whole debate around how current regime, the community sees Modi regime as consistently working to undermine the system of reservation. So I hope I could see some we could see some discussion, we could have some discussion on this. While the judgment to some extent opens the door on subclassification to important reforms, we must ensure that it does not lead to further division among already marginalized communities. And now as we move forward with this discussion, we have Arvind. I would request Arvind to join us. And of course, as we had the last session also with Arvind, where he brought a very strong sociological and political jurisprudence aspect into the discussion, and how constitution was framed and what were the basic thing in the Constituent Assembly. It's good to have Arvind you again. Let's have you on the floor. Thank you, Arvind.
Thanks, Naveen, and thanks to Najar really for this invitation. Thanks to Najar for this invitation, and I recognize, of course, that it's a. Let me get this. Yeah, no problem. Yeah, I recognize, of course, that this is a very passionate issue for many reasons, for many people, and people do feel strongly and passionately on all sides of this particular debate. But as a friend of mine was telling me, that this is one case where we're able to have a debate in a certain kind of a reasonable fashion, right? We're not throwing stones at each other, we're not throwing bricks at each other, we're actually debating, and that's a great step forward compared to a range of other debates which we have in this country now, which things get so polarized that A and B can't even talk to each other. So I'm glad that we're having this, hopefully, perhaps even a strong debate, but debate within the bounds of some kind of a mutual respect, as it were, mutual trying to understand each other's point of view, as it were. And the way I did a paper for this actually for the leaflet, in which like it's not my title, the editor Arif gave the title Subcategorization Judgment, a Progressive Ratio piggybacked by a Noxious Obiter, and so I think the core point I want to really stress on is, what is the ratio as far as judgment is concerned? There's noxious obiters, which includes observations on caste, which are I think unconstitutional in terms of their understanding of the place of caste and reservation within the Indian Constitution. There are observations on the creamy layer, which again are what you call a noxious obiter, in terms of the fact that they're not relevant to deciding the issue at hand. Again, lawyers will understand that the distinction between obiter and ratio. The ratio is something which is irrelevant to the decision you arrive at, and the obiter is something which is not which is not of relevance in the decision you arrive at, and which might be extraneous observations. The judges make a range of extraneous observations, and the role of, I think, within the legal field, at least our task is to identify what is the ratio of the judgment, and do we support the ratio of the judgment? Are we in agreement with the ratio of the judgment? And what do we have to say about the obiters? Of course, the second question. But the core question really is identifying the ratio. And what is our opinion, stand, critique, understanding of the ratio of the judgment? That being said, it's not an easy judgment to decipher, because I think all of you know it's a 545-page judgment. There are 6 judgments and 7 judges. So you have to read all of them to try and figure out what is the ratio, what is the point on which the decision turns, what is the point on which the majority agree. So what is that core, as it were? And I'll try and identify what the core is. The core, I think, you get back to the majority opinion of Justice Chandrachud, because that's the starting opinion, and that's the opinion with which every judge, other than Justice Trivedi, agrees with. So that's really, they agree with it, and they say something more. Something more is the observations on caste with which Justice Chandrachud is not in agreement. Something more is the question of creamy layer with Justice Chandrachud is not in agreement. So the base is, which everybody agrees on, is on the question of what you call the constitutionally permissible modus of classification. That's what all the judges agree on, right? And we'll look at a little bit into the question of how did we get to this position itself. First and foremost, the background, of course, is that the Supreme Court in 17 years ago in Chinnaya's case, again Naveen referenced that. Again, see, there's a link between the social and the political and the legal, and that's very important to understand, right? The reason the sub-reservation, sub-classification issue is even discussing this. Why is it even in the courts? Courts didn't take it up of their own. The reason it came to the courts is because of again, this is very well documented by, we were just talking with Ashna a little earlier, very well documented by Balgopal in 2 pieces in the EPW, where he looks at the entire question of the sub-reservation battle struggle in the Andhra context. And the point he makes is that the Madhika community in Andhra in particular raises the question very strongly. The fact that the benefits which are due for the scheduled caste is unfairly distributed, where they're not getting the fair share, in terms of not a fair share in terms of the percentage of population. Percentage of population and the benefits they get is far less than the percentage of the population compared to the Mala community. And that's the basis of their beginning struggle, as it were. And the struggle gets a political momentum and a political success, where they actually get a commission, the Raju Commission, which comes up with recommendations of how the benefits due to the scheduled caste is to be divided in 4-fold among the 4 different groupings of the scheduled caste within the Andhra context. All of it sounds great and fantastic, etc. But of course, it's challenged, right? It's challenged in the High Court. The High Court, in this case, upholds the classification. It goes to Supreme Court. Supreme Court strikes it down as constitutionally impermissible. Again, what are the bases of the Supreme Court saying it's constitutionally impermissible? You have to go to Article 341, right? 341(2), which basically gives Parliament the power to include or exclude from the list of scheduled castes any caste, race, tribe, or part of any group, right? And so the question here, of course, is include or exclude. What is the interpretation, understanding of the word include or exclude? As far as Chinnaya is concerned, as far as the Santosh Justice Hegde's judgment is concerned, the understanding of include or exclude includes variation, disturbance, includes a question of variation and disturbance. Balgopal's, of course, response to that is, you see, we can interpret, right? There's a space for interpretation in terms of, say, a word like the right to life. Right to life takes on different meanings in different contexts. Include or exclude is on the face of it. It means include or it means exclude. You can't choose to make it mean whatever you want to choose to make it mean. And Balgopal's critique, of course, of the Supreme Court's interpretation of Justice Hegde's interpretation of 341(2) is include or exclude cannot be extended to include disturb, cannot be extended to include variation, cannot be extended to include a range of these other words which Justice Hegde leads into the framework. right? And so anyway, the long and short of the story is Chinaya strikes down, right? So it's constitutionally impermissible to subclassify. 17 long years go by, then we have a 16 long years go by, then it goes to again everything, right? Everything comes from the grassroots level, as it were. The demands are coming from the ground, which go up to the Supreme Court, and that you always have to recognize the fact that the people, the movements, the groups which are raising these issues, which is why it's going up to the Supreme Court itself. Sometimes the voice may not be heard in the mainstream. We may not hear the voice. It may be our job to go and find out who these groups are and why they're raising the issues and why the matters come to the Supreme Court. Again, this links up to another point. I'll make a quick point on that. Is you read Rohit Dey's book, The People's Constitution, right? The point he's making is we have to find out who are the people behind the litigation. And the point being that if you go to the state of Bihar was the Quraishi community which takes up the question of cow slaughter, right? And why are they taking up the issue of cow slaughter? They're taking up the issue of cow slaughter not because Muslims have a religious right to slaughter cattle, right? Which is the argument the court is familiar with, but because the Quraishi community makes its livelihood from the question of cows or from the question of cattle, right? So the question is that the question of trade and profession is the core concern as far as the community is concerned that emerges from understanding who the petitioners are. So the similar point being in this case, I think it's absolutely vital and central for us to understand who the petitioners are and why they're taking the matter right up to the Supreme Court. So that's the Chinaya story. It gets up again the three judges. This again, there's a range of legal complications, the complexities around this. Three judges. Again, I think Naveen's invocation of the politics of it all is a very important one. Three judges, headed by Justice Arun Mishra, who is now the chairperson of the NHRC, who otherwise we have seen, right? I mean, as subject to enormous critique in terms of delivering judgments on the side of to aid the government in power. There's no doubt about that, right? He gives a judgment, three judges, saying that we think that the judgment in Chennai is as constitutional is a violator of the later judgment in the Dasani. So, or a violator of the earlier judgment in the Dasani, and therefore that the larger bench should look into the matter. Again, very, very interesting. The minority judgment in this case, the judgment which defends Chennai through and through is Justice Bela Trivedi's judgment, which I don't agree with at all. But the one point she makes is absolutely vital. She says, how on earth, the three judges even hold that the matter should be referred to a 7-judge bench? They're bound by the logic of 5-judge bench. How is this even possible within the logic and understanding of the principle of precedent? Very, very important point from the understanding of law. And she's raising, again, very rare, right? Do you agree with anything Bela Trivedi says? But this point, I think she's right. On the question of how did he even get to that point of a 3-judge bench saying that a 5-judge bench is wrong and it should be referred to 7-judge bench. 5-judge bench can say it. How can a 3-judge bench say it? 3-judge bench is bound by what the 5 judges say. That's what it should be, right? So she raises a very important point. Anyway, leave that aside. Okay, so 3 judges say that, right? And what did the 3 judges say? I didn't tell you. 3 judges basically say, yeah, that it needs to be referred to a larger bench. Sorry, 5 judges say it needs to be referred to a larger bench, right? So it goes to this. Finally, it goes to a 7-judge bench. Right? 7-judge bench is constituted to look into this particular matter, and that's the judgment which we're currently discussing, and that's the one I refer to as 500 pages plus 6 opinions, and the controlling opinion in this case is the opinion of the Chief Justice, which is Chief Justice Chandrachud, right? And when we ask the question subclassification, right? Again, you would ask the question: where do you root? What is the constitutional principle which underlies subclassification? Right? Where do you find the constitutional shade? What's the constitutional justification for subclassification? That's the question you would ask. Right? The bar, of course, which Chennai erects is the understanding of 341(2) and the idea of include or exclude. That's the bar which Chennai erects, right? And the understanding of the Chief Justice is you locate the principle of subclassification in 14, the principle of equality and the equal protection of laws. You locate it in the question of 15(4) and 16(4), which is the idea that you can take measures to protect the interests of those who are marginalized, right? Who are socially and educationally backward or other backward classes. And the understanding here is a very important one, is the idea that the principle which underlies the equality provisions of the Indian Constitution is not formal equality, but substantive equality. Formal equality will say, I mean, again, for formal equality will say that the law equally prohibits both, again, in a famous line which Krishna uses in the N.M. Thomas case, that the law equally prohibits the rich and the poor alike from sleeping under the bridge. But the Indian Constitution is not that. The Indian Constitution's logic is that we have to make a provision for those at the very bottom of the socio-economic hierarchy. How do you make a provision? You make a provision to the principle of what you call classification. Classification, what is the forms of classification are constitutionally valid? Reservation is a form of classification constitutionally valid, but the other form of is constitutionally valid. So the logic the court goes down in this case is saying that if the power which we have on Article 14, 15.4, and 16.4 is what gives us the basis to classify even among the scheduled caste and the scheduled tribes. And of course, it's not an unlimited power. The power is guided by the principles of classification, which is you must be able to make an intelligible differential between two groups, and there must be an objective which you want to, for the reason for which you're classifying. And the way the court reads it is that what is the intelligible differential within the group called scheduled caste? That's the question which you have to ask yourself, right? And the way the court reads it, to get to that question of intelligible differential, they look at what Naveen was indicating again, look at empirical data, right? Look at the Usha Mehra committee report, they look at the entire Raju Commission report, they look at the civil society fact finding in terms of the entire question of Martin McMahon's work. And what all that literature indicates, is that in the Indian context, if you're looking at the category called the scheduled caste, the upper among the scheduled castes ends up honoring a range of the benefits which are due to the scheduled caste as a whole. That's the empirical documented reality. And the Raju Commission indicates that the Madigas get an unfairly lower share. The Supreme Court judgment again indicates that the evidence before it shows that in the Punjab context, the Mazhabi Sikhs get a lot less as compared to their share of the population. Of course, in Andhra, the Madigas get a lot less. In Karnataka, again, the Madigas don't get the share of what they due as far as the proportion of their population is concerned. So, from that question, what the courts arrive at is there an intelligible differential? Right? The intelligible differential between the upper and the lower because of the fact that one gets benefits, the other doesn't get benefits. Point one, in terms of the percentages. The other intelligible differential which the courts obviously arrive at, based on the looking at in particular the Martin McMahon study, etc., is that there is a level of discrimination inter se between the groups in the scheduled castes. And again, the Martin McMahon study in Gujarat indicates that I think 1,000+ villages in Gujarat, that the upper among the Dalit communities does not allow the lower among the Dalit communities to the access to religious spaces, access to funeral spaces, access to burial spaces, etc. It's a range of criteria on which discrimination inter se happens is what that study documents. So using the empirical data and using this logic of intelligible differential, the court arrives at the fact that classification is constitutionally permissible, or there's a constitutional logic to classification. You're classifying based on certain kind of constitutional logic or constitutional thinking. Your objective, which is to achieve substantive equality. To achieve substantive equality, there's an intelligible differential between these two groups, and you're making the intelligible differential, and that's the basis for subclassification logic as it were. One more point they make in terms of interpreting of 341, right? If you read the 341 provision, they refer repeatedly to the fact that 341 uses the language of it's a deeming provision. I'll just read to you what it says. It says, specify the castes, races, or tribes, the parts of groups within caste, races, or tribes, which shall be, for the purposes of the Constitution, be deemed, be it scheduled castes in relation to that state. Right? So it's deemed. So it's a constitutionally created or legally created category called scheduled caste. That's the logic which the court uses. So it's not a category which has a life necessarily outside the framework of the law. The law creates this particular category. Of course, it takes on a social life later, but the way the court frames it, it's a you deeming this grouping. And again, what are you deeming, right? You're deeming as a scheduled caste a range of castes which come within that particular grouping as it were, right? To form a scheduled caste. So if you can deem, then there's a way in which you can look into the question that the court says if it's deemed as a categorical scheduled caste, nowhere in 341 does it say, or 341 1 or 2 does it say that you can't look at the distinctions inter se, or you can't look at the differences inter se, you can't look at the hierarchies inter se. Okay, so far the court gets. And finally, okay, what can we do about it? That's the question. I'll end with this last point. The logic the court comes up with, or the majority opinion comes up with, is there are two ways in which you can potentially classify. Right? One, what they refer to as the preference model. The second, which they refer to the exclusive model. Both both have two subcategorizations within it, right? And one is constitutionally permissible, one is not constitutionally. One is constitutionally impermissible. Okay, and I think I'm confusing everybody. I'll just go one by one. Right? If you say the exclusive model, basically, if there's 20% reservation for scheduled caste, right? Out of which you can say 5% reservation is exclusive for the Madhika plus plus communities. I'm just taking the Madhika example, Madhika plus plus community, right? And 5% exclusive for the Madhika plus plus communities. And if there is if that 5% if that 5% is not filled, it can go as a roster to the next year. That's the exclusive model, right? Exclusive model, what is not constitutional, that's constitutionally permissible. What is the exclusive model which is not constitutionally permissible? Is it 20%? The entire 20% is exclusively for the Madhika plus plus communities. That is not constitutionally permissible. So you get the point of what is constitutionally permissible is 5% in the exclusive model. Right? And again, the court goes a little into the logic of looking at Nagaraj judgment. Can you have, right? Can you have a reservation in terms of promotions? Can your reservation goes into the next year, etc., etc.? All of which is constitutionally permissible, provided it's not 20%, it's 5%. I'm just giving an arbitrary number, but it's not 20%, it's 5%. Right? So that's constitutionally permissible. The second model the court references is what it calls the preference model. The preference model, again, say 20% is the reservation category, out of which you have a preference, right? Out of the 20%, first preference for the 20% reservation goes to Madhikas. If there are not enough Madhikas, or Madhikas don't get into the seats, then it can go to the other communities. That is constitutionally impermissible. Why is it impermissible? Because it's possible that the entire 20% could get filled with Madhikas. And that is, then you're excluding the other groups as it were. That's not permissible. Right? What is permissible is if you say that the preference, right, is the Madhikas have a preference over certain section, right, of the reservation, and if they don't get, if they're not enough Madhikas to fill that, the 5%, if they're not enough Madhikas to get that 5%, then that 5% reverts back to the parent category. Right? So that preference again, you can't have preference of 20%, but you can have preference of 5%. And that 5%, if you don't have enough people to fill that 5%, it goes back to the parent category, which is the scheduled caste, with the other scheduled castes are entitled to utilize it. Right? So again, these are the two constitutionally permissible modes. One mode is the exclusive model, which is 5%, and one model is preference model, which again could be 5%. Right? So that's what is possible as far as the reservation as far as the constitutionally permissible modes of reservation. So I'll just end with that and say that this is what the judgment lays out, and maybe I'll just end with two other quick concepts on this, which is, I think Naveen raised a range of issues. I guess possibly we can get into that in the discussion. But we were just talking about it. The reference texts maybe that you look at the Balgopal pieces on writings on reservation subclassification, which are very useful. And I think Naveen has said end in 2 minutes. So yeah, I'm ending with that. Yeah, done.
Oh, you have ended, Arvind.
Yeah, done.
So I'm sorry to disturb you. Yeah, I mean, every time I think whenever we have heard you talking, the way you have kind of beautifully brought in the whole constitutional discussion and debate is so good. I mean, uh, we really need to have a separate session with you, Arvind, specifically on this thing. And it's very good that, when we talk about intelligible differentia is not only about, the whole aspect of equal among equals and unequal among equals. It's like the way now we are kind of trying to talk about equality among unequals, and the way it is more important now, and what you have very specifically talked about constitutional mode of subclassification, what exactly it is. And I'm not saying that the judges who have kind of given those judgment are very much, constitutionally wrong, but um, I mean, yeah, the way the Article 341 was supposed to be interpreted has different meanings, no doubt. And the way you have very beautifully kind of mentioned about what Article 341 talks about and how it has been interpreted in the past, and especially in Chinnaya's and this judgment, is pretty important to kind of talk about this. And yeah, I mean, we'll surely have you, Arvind, in the next part once we complete. So now I would request Rais Mohammed to kind of talk about how the whole debate which has been reignited by this aspect of subclassification has reignited the whole debate around what exactly Dalit identity is. What exactly, I mean, it's us who is deciding who are Dalits, or it's Supreme Court or the legislature is deciding, okay, now you're not a Dalit or you're a Dalit, all those aspects. So it's is it the movement which is deciding? Is it the people who are deciding, or is it the administrator or the judiciary which is deciding these things? So can we have you, Rais Bhai? Are you available?
Yeah. Hi.
Sure. Thank you.
Am I
Thank you,
audible?
Rais Bhai. Over to you. You have 15 minutes, Rais Bhai.
Yeah. Okay. Thank you.
Thank you. Thank you.
So yeah. See, I actually the Supreme Court judgment, and before that, what I want to bring the audience also, since the Chinnaya judgment or the subclassification itself, there are two ways of looking at subclassification debate. One is constitutional debate and bureaucracy, implementation, and policy level subclassification, that they are not represented. So when you limit, like Chinnaya's understanding, if you limit that argument of subclassification that Madhya has not received and Arundhati are not receiving, or the Valmikis are not receiving, if you limit that understanding to that SC status alone, then I think the problem on the ground is the result of that. Like chamars are protesting, and people say that we are all debating very maturely. Actually, that is not the case on the ground. It is violently being polarized, and for the first time in the history of anti-caste movement on the ground, it is completely polarized, and in the North India polarized. And many people said that Valmikis have announced that Mayawati has announced that I'm not going to those who support subclassification don't be in our party. And Valmikis also said that we are not going to be part of BSP. So they have been coming out of BSP, and in Tamil Nadu there has been a great differences of debate of that became a caste debate, like Parayar versus the others. Parayar means I'm not talking about the all members, because that's what I said. The debate of constitutionally category of SC, and talking about policy level matters, and people thinking that you're not represented. So therefore, some Chamars and Mahars used to say that, why don't you, like JNU student, student will say that, why don't you give economical policy for them to upcome, rather than divide the SC category itself. So that is, if you limit that argument to that level, actually, but that is not the case. I think this is a recent Supreme Court judges were the only people, I think, to look into this debate of what is the demand of Malas and Madhyas and Arundhadiyas or Valmikis actually on the ground. So, for an example, what I would say is SC category itself. See, for example, and this the flaw Right now, if Supreme Court has intervened in this, means it is a failure of the Dalit movement. And I would say partly also the progressive movements also. But mostly I think that blame has to be with the Dalit movement, especially the SC/STs representatives in the bureaucracy, SC/STs representative in the MPs, MLAs and ministers. They are, I think all of them failed in addressing these issues. What issues is, for example, backlog posts are there. So many posts are not being filled. They should have taken a step. Even now, nobody is talking about that in a serious manner. Only to counter this argument they bring. But at least they should have taken up this issue even before it went to the Supreme Court, or at least before this, after the Supreme Court, at least they should have taken up that issue. They haven't taken anything until this day. They haven't even, for example, I would bring this one on the measure of on the welfare or the self-respect of. No, no. Let me put this way. Until this day, not a single SC ministers, MLAs, MPs, political parties have talked about uh, municipal workers, sanitation workers. Why? The simple reason is all of the academicians and the ministers who are articulative are not from this community. So, for example, if you take, I would take only Bejawada Wilson, NGO, Bejawada Wilson as a social movement person. He is the only person for the last 1 decade been addressing about sanitation issue. Why Dalits are not addressing? There is another problem also with that. All the writings on sanitation work has been done by non-Dalits and few work by Dalits. But why Dalits who study or in academics, I'm not saying Dalits, at least why such an articulative is not coming from them is because I think the SC category itself in this India has become a category of claiming that one identity which is on par, one identity to equate with Ambedkar's and annihilation of caste theory. Let me put that another way. In Annihilation of Caste, Ambedkar wrote the text for the non-Dalits. And he clearly says, I'm writing this for John Park Total Mandal, who's an upper caste Hindus, and I want to present this paper. So I'm not allowed. So he's publishing it. But now what happened is Dalits have taken up this book and said the caste problem is not for Dalits, it is the upper caste. So we are all one, the rest is the other. So therefore, the SC category as a homogenized category, as a one single category, they imagine that that is we are all homogeneous category, and therefore caste has to be annihilated from the upper caste angle. I think that has been a problem, and in Tamil Nadu, at least in 2000, since the 2000, the articles which have come out, and I think even earlier also there has to be something, and at least some people, some that too Dalits only, because even now, if an Arundhadiyar in Tamil Nadu is attacked by a Paraya or a Pallar, nobody will talk. Not a single media will address, not a single YouTube channels will discuss one or two, but it will never become a national issue. Another, for example, classic example is before the Supreme Court judgment was delivered a week before, Chakliyar's head, a youth's head was beheaded and his body parts were in different parts of the 100 within 100 meters. The simple reason is he fell in love with the Pallar, another SC community. Then we go to another part of this Ottanjatram. There are many issues actually. When I get into Tamil Nadu, after my studies, when I get into Tamil Nadu and I see so many violences, and how do you differentiate these violences? I can't understand. You cannot say that. I don't know whether how can somebody differentiate the violence by saying that this violence is upper caste attacking Dalits is different, upper caste raping Dalits is different, and Dalits raping Dalits is different. I can't differentiate that part. So therefore, I'm saying that we are never equal. We have never been equal, and we have been never been treated equal, and we are treated, I think, worse than the OBCs. For an example, in Tamil Nadu, VCK Vidudalai Chirthigal, Thirumavalavan is the head of that party. He will go and align with all the caste Hindus. He will never ever address or even refer a Dalit Chakliyas leader's name on any of the stages. But these Chakliyas leaders will always consider him as a godfather for Dalit movement, at least a big person, big brother person. But this person will never ever. And any violence happens, his party leads that crowd. Last 1 week before in Tanjore, people from Chaklir community, 100 people are living there, 500 people Parayars are living. Pariah's VCKP members are beating them like anything, filing cases after case. That guy is telling me 100 people are there. We don't know what to do. Media is not coming. YouTube channels are not coming. No progressives are speaking. So what will I do? They were asking. So after that, I said they are in the northern part of Tamil Nadu. Then the last one point I would say, in Chandayur, they built a scavenging communities living, and then the Parayar communities are living. And Parayar community, one day they decided that we will build a wall, and they said that we are protecting the temple, and they restricted the access of Arundhadiyas. This happened some few years before. Not a single channel, TV channel debated. Because why? They said VCK is involved, a major political party is involved, and these guys are in Chaklias, do not have voice, so that they left us. YouTube channel said that no, we can't go. And at last they went to the forest and they were protesting in forest. They vacated their house, they protested in forest for 1 month. Nothing came out. They went to the court. Court said that yes, this is an illegal construction. We should demolish. Then the VCK party said that okay, we will demolish, and they just took some 2 stones and said that we demolish and gave it to the court. And these guys do not have that much capacity to go to the Supreme Court. So now both the communities, interestingly, something happened in that issue. Parayar, in that fight, Parayar women fell in love with the Chaklir men. And they both, while these communities were fighting, these both fell in love. And this love was going on. After 1 month, when they returned home, this couple ran away, eloped. Interestingly, the Parayar women's family members, uncle, supported that, and his uncle is a very strong person. He said that this community will be fighting like this. You just leave this place. And he took a work for the Chaklir boy, found a work of a Chaklir boy in his own land, Parayar land, which is dominated by Parayar. He made them to stay there for 1 month and settle the issue, and they brought them back. What is very interesting is, on the ground, people are ready to mingle. But political party, what they did, they entered and they made sure that both the sides filed cases. Now both the people are running after courts. And I am calling both the parties, and especially VCK, and telling them, if you want to change, bring a change. The community is ready to change, but you people should initiate that change. And why don't you initiate from there? Nobody's ready. They're saying that no, we can't do that. So my entire point here is, when we look into cases and laws of constitution or something, it is for the people. And when it is for the people, if there is ground, it says that we are not equal. And that is what the Supreme Court has found out after these many years, and higher judges have found, yes, they are not equal on the ground. See, my father, entire sanitation workers, nobody has used SC certificate to get a job. For us, SC status is not SC government policies. We are not interested at all. But don't treat us equal. When you speak about Parayar, you're speaking about Chaklirs also. Chaklirs are not that. We are different. Nobody's addressing our issues are very different. Manual scavenging is there everywhere. Now I have to come and I have to say that even in septic tank there is manual scavenging. Now I have to come and argue that entire sanitation workers in Tamil Nadu are bonded laborers of Tamil Nadu government. And now who's arguing this apart from us? Because the political situation is like that. Each person should represent his own problem. Nobody's ready to. It is only few people like Balagopal or even Arundhati Roy, or some people, great leaders like Kanshiram and Ambedkar. You forget, that is out of the chapter. Right now, I don't find any Dalit leader who would come and say that we will fight for all, we'll bring all the issues. No, I haven't found any leaders in India right now who could come and say, let us join hands and let us address their issues, and at least we'll recognize that issue. That is not the case. So therefore, I would end my talk saying that we are not equal. It is not that I'm saying we are not equal. We are not treated equal. And this is not some NGO issue that you say that don't we'll treat equal. No, it is a social issue. And caste is understood not like an Parayar versus something versus BC. No. Caste is an individual problem. That is also the Supreme Court says. It is an individual problem, and it also, and other people also say it may be problem for Arundhadiyas now, and some community who do not have numbers, they would come and tell Arundhati is also discriminating. Therefore, caste is an individual problem. That is what Supreme Court has said. Annihilation of caste is not a text for them only. Annihilation of text is also for Dalits. Intercaste is also to be recognized between SC communities. Intercaste is not only about marrying BCs and SCs, which many Dalits would argue, especially Mahars and Chamars and Malas, to marry an upper caste woman, especially. So, but that is not the case. Annihilation of caste means you marry a Valmiki woman, Valmiki boy. That kind of a, we don't want brother-sister relationship, we don't daughter-in-law, son-in-law relationship. That has to be happened to eradicate caste. And I think Supreme Court judgment has taken up in that way. Thank you.
Thank you, Rais. I mean, the grassroots experiences which you have and the way you have kind of compared different situation uh, is an eye opener for most of us actually sitting in this thing, and that also brings the whole aspect of how do we treat different communities uh, within the scheduled caste communities. What perspective do we have towards them? um, how are we kind of looking at them once we talk about violence, once we talk about employment, and especially the whole case of manual scavenging itself. Yeah, I mean, apart from this, I also kind of, have been having discussion upon how this whole aspect of, uh, you know, discrimination within the scheduled caste community through the whole process of Brahminical approach has very extensively impacted Rais. So thank you for bringing it up, Rais. Bhai, we'll have you for 5 minutes after we request Ashna to speak, our next speaker. Very interestingly, now we have Ashna, who will also talk about how one of the judges has tried to, sanitize the caste system through reference in Vedic Hinduism. So, uh, Honorable Justice Mittal, of course, has very specifically referred to Bhagavad Gita. He has referred to, please correct Ashna during your intervention. He has referred to Skand Puran. He has referred to many other texts, and to some extent negated that caste system never actually existed in ancient India. I mean, it was like a Brahminical machinery has found an opportunity through this judgment to insert its own ideology. Is something which I kind of realized through this judgment. And then he takes a different approach altogether, saying that no, it doesn't exist. It was existing early. It never existed in an ancient Hindu, and this whole uh, aspect of reservation, it needs to be relooked from a different version, from an economic criteria, and of course suggesting that the reservation should be limited to the first generation itself. So without taking much time, I would request Ashna to quickly take the floor and take forward this discussion. Thank you.
Yeah. So I'll be talking about what Arvind referred to as the noxious orbiter and just trying to understand why it's dangerous, right? I'm sorry, my throat is a little bad, but I hope you can all hear me. So Justice Mittal doesn't talk so much about the constitutionality or unconstitutionality of subcategorization itself. He writes more about the idea of caste, the concept of caste, and how everybody has a flawed understanding of it except for himself, right? And what my issue with that is that it's sort of propagating a certain kind of stereotype of Dalits, of reservations. And this is something that I've also written about in the context of women, about how the court relies on these ancient texts, which are not really sources of law for the purpose of giving judgments, and using them to stereotype women either to arrive at good judgments or at bad judgment. Like, for example, if this judgment, if we see it's a judgment on subcategorization, that there should be subcategorization, etc. But the process that was followed by certain judges, such as Justice Mittal, and the kind of stereotyping he does of Dalits in order to reach a conclusion that is benign, is something that is problematic. So basically, I'm trying to draw your focus to how both the process, the reasoning, and the outcome should, not do this kind of stereotyping, and should rely on proper sources of law in order to give a judgment. So, for example, he says a lot of things that, that merit should be the only basis on which a society should be built, right? And saying things like reservations are a burden, that they've caused an immense amount of litigation, the burden on not only the society, because for example, protests happen for reservations, and so therefore they disrupt peace in society, and then it leads to a lot of litigation, so it increases the court's burden. So it's making a lot of unempirical statements, right? And these are, a lot of this is like dinner table conversations that a lot of upper caste people have in their household, and it seems like it's a written thesis on that, right? Then of course, like you also said, Naveen, is kind of saying that caste is not really a birth-based distinction. It's more of an occupational category based on your duties. He also says that people started to allude to their own caste, and that's how they propagated caste. Dalit people started to take their Dalit parents' surnames, and therefore they started to identify themselves as Dalits. So very, very stereotypical and obnoxious statement that is made, that that people became Dalits, or people became Adivasis, or people became Brahmins by choice, right? Then even if we speak of stereotypes, you see the first commission before Mandal, which was a Kaka Khalilkar commission. It also stereotypes Bahujan people by, saying that these are people who did not care for their own education. And so therefore they are suffering. They are the cause of their own suffering. And so why should we make reservations for them? And even when it sort of agreed to give reservations, it said that, that they can be given reservations in group C and group D mostly, but in group A and group B, it has to be, protected from reservations, because again, kind of making the alluding to the idea that because the OBCs were a servile class, and so therefore they are best suited for group C and group D jobs. And so that kind of stereotyping is something that we see a lot in commission reports as well as judgments, but somehow we just brush it off as being obiter, or as being, said just by the way. But I feel like they may have an impact, especially if, even if you see the Patna High Court judgment on increasing reservations, and how the merit argument again comes over there, right? So, I mean, all of this is a play on stereotypes about Dalits, about how unmeritorious they are, etc. And then he's saying that, reservations are a privilege, they are meant to appease Dalits, they're only leading to vested interests, right? And what all are we going to do in the name of Harijan welfare, and for how long, and when will they get off these crutches? So these are the kind of statements he makes, and this is something that I call as theocratic Harijanology, and I'm referring to Gopal Guru here, who says that this whole idea of Harijan sort of gives a theocratic parentage to Dalits who are otherwise not divine, untouched by not just people but also by God. Right? And Gandhi sort of comes and gives them this divine character. So, and Justice Mittal sort of uses that, he uses the word Harijan a lot, for example, and that's why I'm calling it as, this kind of borrowing from Guru's theocratic Harijanology, or theocratic parentage is what Gopal Guru says. The other thing, then he says that, constitution, when we made it, we were, it was a pure constitution, and then suddenly this impurity of caste again comes to uh, create blemishes in the constitution, right? So again, this is again ignorant of how Ambedkar viewed the constitution making process, where he meant it to be an antithesis to the idea of caste itself, and he considered caste to be the law of the land, and the constitution being an antithesis to this law of the land which had prevailed until then. So therefore, this binary of how this was a pure constitution and it was made impure because of inclusion of reservations and untouchability, etc., is something that is completely ignorant of all the fights and struggles that anti-caste figures have had, legal struggles especially. And Manoj Mitra writes a lot about these figures in his book Caste Pride. Um, so I think, yeah, just to sort of conclude, which is that I want you all to think about how these so-called orbiters may have an impact on any kind of policy making. For example, in Kaka Kalilkar, it did, it did have a role to play over there about this, the stereotype of the OBC person was on the basis of which the report was informed by that stereotype, right? So, and a lot of judgments are all like Champaka Dorai Rajan also in very implicit ways, also sort of relies on that kind of a stereotype. Right? So it's in this judgment you see that there's an overt reliance on these stereotypes. And just thinking about, how should judgment writing happen, what are the sources of law, what is the hierarchy of legal sources, right? Can we really use Ramayana, Mahabharata, etc., to come to conclusions, good or bad conclusions, that regardless. And one more point that I want to make is about whereas Chandrachud has given a very reasoned judgment, and he writes that this is something that the judiciary will review whenever subcategorization has to take place. But the question remains about what happens when he goes away. And will people have that trust in this kind of judicial review, and considering the political climate, collegium system, and the role that a government can play in the appointment of judges, where how will the subcategorization, um, how will it be implemented, basically in the way that Chandrachud envisages, and not in any other way. Yeah, that's all. Thank you.
Thank you, Ashna, for bringing it up. And I think this was really important to have this aspect of the judgment, because to some extent it also reflects how and what is exactly the mentality uh, which the judges, the topmost judiciary, and of course to some extent at the administrative level is holding at this point of time. And that's where the whole discussion of the political environment comes in, which I'm sure would be very interesting to take forward with, because we don't have much time right now. But we'll surely request you to give us more time in the upcoming series. So we are planning to have series as we discussed this earlier on this judgment specifically on different aspects, because it's a very important thing to be discussed about. And we have different views from different civil society organizations, from different lawyers, from different academicians, and of course, the social activists. So it will be very interesting to have this discussion, broader discussion on this whole aspect of how this whole idea of sanitization of caste system has been kind of pushed in through a Brahminical approach, and how and what exactly Harijan means, from where this term came, and why it has been used so often by topmost judicial officers, administrative officers. So that whole level of sensitivity, and it's not only judicial officers, Ashna, it's even people from our own community who are kind of using the same term. Very, very extensively, they're using the same term, and it's not like they are to be blamed, but it's just the whole aspect of awareness and what it actually means is something which we need to take to the grassroots. And that's the point where the civil society organizations.
And it's also contradictory in the sense that we think of reservations as parity, not charity. But when
Yeah,
you
yeah.
bring in stereotype of Harijan, which is a charitable pejorative term, it's a complete contrast. Yeah.
Oh, yeah, exactly. And of course, this whole idea, and of course, this whole discussion around contrast is something, let's take it forward. Ashna, we'll soon try to have another discussion around this and see how we kind of enlighten more about this with a larger, broader group. It's because there we no doubt have access to books, we no doubt have access to education. There is a whole lot of community, especially Dalit community, who don't have access to, and they are mostly driven by what happens on the social media or WhatsApp and other things and local discussions. So let's also see how do we take that forward. So thank you, Ashna, for giving us time. We have 15 more minutes, 15 to 20 more minutes. So I would request if there are any questions from the speakers. I think Chaitanya had one. Chaitanya, do you want to go forward?
Yeah.
Thank you.
So I have two questions. One is a constitutional question, and one is a socio-political question, you can say. So, Arvind sir, we talked about intelligible differentia and the empirical use of empirical data whenever it comes to granting of rights of reservations in jobs, employments, etc., etc., Supreme Court strictly asks for empirical data, which it does not on when granting other rights. So it casts an unequal, rigorous, strict burden of proof when granting reservations to Dalit communities or DBA communities, right? So is that really intelligible? And is that really the way that we should go forward in this subclassification issue? First is that. Second is that when we are as Rais Mohammed talked about how Dalits are facing atrocities from Dalits only, then are we talking about the subclassification as a constitutional question or as a socio-political implementation question? Is it an implementation thing, or should we look at it from a constitutional lens, and should a constitutional bench decide on the question of law? Is it really a question of law that we are talking about?
So thanks, Chaitanya, right? Chaitanya, thanks.
Yes, sir. Yes, sir.
Thank you, Chaitanya, for your questions. Thanks for taking time to think through a little bit of the concerns around the issue. I think both are very, very good questions. The Your first question, right, on the question of, what is the necessity, importance, value of empirical data, and is an unfair burden cast on the question of caste in terms of producing empirical data, right? That's your question. And uh, I guess you go back a little bit to understand where the impetus, the imperative really comes from, right? And again, Ashna referenced this. Go back to Manoj Mehta's book, Caste Pride, right? Which looks at the way this entire process begins, right? And the idea that you have a social reality, right? And you have to make sense of the social reality. You have to see the social reality as graded or hierarchical or different or just difference, right? And Ambedkar's, of course, great contribution and innovation is saying that we have to understand what is going on as graded hierarchy, right? And the point is you can say it, but it will be empirically demonstrated as graded hierarchy. Once you demonstrate this graded hierarchy, then you can have a range of ways in which you intervene in this kind of a system, right? And that link, I mean, one more point maybe on this. It's a good question because not an easy one, right? I mean, how do you what are the parameters you arrive at to say that this group comes within the category of scheduled caste, this group doesn't, right? And go back to the again what the judgment references. Urge you all to read it. It references Ambedkar's submission to the franchise committee, right? And where the question is asked, I think my understanding the question is asked, right? How do you say this group is entitled to representation, right? You say untouchability. What is untouchability? Right? And he says untouchability is a notion. It may not apply in the same way to each state or each region. Each region might have a slightly different way in which that particular system, the notion of untouchability operates. Right? It can't be as specific as saying unseeability. You can't have that as the standard. It may be different districts. Again, go back to the judgment, right? It's a very complicated question. I get what you're saying because the judgment makes the point in Madhya Pradesh, right? The question of who is a scheduled caste. Again, colleagues on the group on this list on this Najar list may be able to make sense of this point more fully. The judgment makes the point that some groups are scheduled caste in some districts, not in other districts. So that's one kind of thing. In Karnataka, the problem you have is there's the classification is such that the majority of the benefits of reservation are actually cornered by what are called the the, the touchable communities because of the history of reservation in the Mysore region. The reservation continued from that period onwards, and some touchable communities are part of the list, and they end up cornering the majority benefits. So there's a crying need for subclassification, right? In that context, where you're saying that one grouping is cornering the majority of benefits, as it were. That said, at the last point you make, I'll just finish the last point. Is it a constitutional principle? It is 100% a constitutional principle. 100%. Because the question is, when you say it's graded hierarchy, as Mr. Rais indicated, with graded hierarchy, then your constitutional mechanism has to target graded hierarchy. And if your point is graded hierarchy doesn't stop at the category of scheduled caste but pervades the category of scheduled caste, then your constitutional mechanism is target that as well. So subclassification is one strategy to address precisely the concerns of those at the very bottom, right? In terms of people in manual scavenging, right? If the people in manual scavenging, if they're not getting the benefits, right, of the entire framework of reservation, then one way forward is subclassification. Again, subclassification, as I explained, constitutionally permissible modal subclassification. You can say, for example, right? You can say that again, so going back to the example of the Madhya community, you can say the Madhya community has the first call on 5% of the reservation. If there's no members of the Madhya community to fill it, then other members of the scheduled caste parent category can have access to that benefit, as it were. But then again, your point being that is the only constitutional strategy subclassification? No, 100% that can't be answered. You have to think of other modes of intervention as well, which go outside the framework of subclassification. But subclassification is one strategy, one a constitutionally permissible strategy to address the entire question of graded hierarchy.
Uh, but sir, when we talk about granting protection to
Chaitanya,
marginalized community, yeah,
Chaitanya, let's wait if somebody else has a question, then we can
okay, yeah,
come
sure,
back.
sure.
Sorry. Yeah. Anybody else has a क्वेश्चन किसी और के कोई भी सवाल आप हिंदी में भी बोल सकते हैं.
Mr. Rais could also respond to this Ashna as well. I think, no, I mean, this question, sir. If they want to.
Okay. Yeah, just give me a second. Okay, just give me 2 minutes, Chaitanya. Maybe we'll go back to Rais bhai. Rais bhai?
Yeah, hello. One thing is, sorry, Naveen, Satish, Naveen bhai. I couldn't give my introduction because I'm actually, I resigned from my English from Madras University. And then now I'm running a septic tank cleaning business. This itself shows why we need subclassification. See, we are not, when the subclassification, it's very funny. When the subclassification judgment came, not a single sweepers community across India celebrated it. Have you seen? My community members in themselves do not know what is subclassification until this day. But there's a big political debate in Tamil Nadu between subclassification we need or we don't want. Because subclassification is not about constitution alone. I think Tamil Nadu government was the only government to make I think because of the Dravidian land, Tamil Nadu government is the only government which said these communities are doing manual scavenging and they need to be uplifted and then they are not being considered equal. Therefore, we need to subclassify, which is not the case in Andhra Pradesh, if I'm not wrong, in any other state. Because social and constitutional empowerment was seen in Tamil Nadu. So I resigned from my work because the answer for this, our Chaitanya is also the same. I resigned from my English and Foreign Languages University. The simple reason is my research finding was that the root of caste discrimination is there in sanitation. That you may disagree, you may not disagree. That is my research argument. So I went to IITs, IIMs, everywhere they were laughing at me. CSDS laughed at my proposal. Seriously, they laughed. But I want to remind the CSDS, recall that interview. I told them that in the Indian Institute of Advanced Study, Viceroy Regal, there are 3 entrances. One is main entrance, servants entrance, and sweepers entrance. This is there in the architect design. So what I found is the Britishers adopted the Indian culture and made sure the servants and the sweepers are not equal, which they needed, the society wanted to look at them. This was my finding to understand the architecture in India. CSDS laughed at me. Anyway, so I went and said sanitation is a serious issue. I went to my political party, Dalit parties. Everybody laughed at me. They said, you know what? They mocked at me. They said, you know, sanitation workers do not need to have self-respect because that work itself doesn't deserve to be a work at all. Everybody should leave that work and come out of it. We are not going to address their issue. They are not even an identity also. They are not even our identity issue. Then I said, if they leave, it is fine. That's an NGO argument, but still, I'll go with their argument. If you ask them to leave that work, but then others are going to come and occupy. One. Second thing is, Ambedkar repeatedly said, I am a scavenger not because of my work, I am a scavenger because of my caste. Wherever Ambedkar did, he was the most educated person in India. He was the most celebrated icon in India, but still he faced discrimination. So caste is inbuilt. Therefore, he did not say that let us go and do some postdoctorate in Cambridge, our education will go. No, he said, I am born as a Hindu, I will never die as a Hindu. So he found that caste is a social problem. So social problem cannot be elevated through this jobs and economy. Maybe all a reason to it, but social is a central to it. So therefore, I told them you should address this. Nobody was ready, brother. Therefore, I resigned. I didn't get the job. I didn't. I love research. I love research, and I was not allowed because I come from a Chaklir community. No professors were interested to take me because my community, I don't go with community. Okay, believe me, I don't believe I don't go with community, but everybody looks at me as a Chaklier. So malas and mahars and chamas who are there in higher institutions, they don't even encourage such idea to even be researched. And then what I did, okay, because research there's no option. Social movements are not taking this issue. Therefore, I left my job. Then I said that I myself will come and do the sanitation work. I'll organize them and I'll form a self-respect. When I was forming a self-respect, I found a very interesting argument. This is where I said caste is an individual problem. It is not a community's problem. It's an individual's problem. Every individual in India has a caste problem. The gravity or velocity can be different, but individual problem. How I'm saying this is, my community works as a sanitation worker. I thought that everybody, okay, they work, they do say, we get this identity mark that we are sweepers, and we can't leave that, but it is very humiliating, they used to say. I also take that argument. But also they would say this is giving a food for us, therefore this works for us a labor, like any other work. But however, on social level, we are not considered equal, therefore that stigma is there. I found, okay, that is normal everywhere, because in Tamil Nadu, you should know this, in Tamil Nadu, a particular political party from this sanitation working community, a few years, 10 years before, they organized a protest, saying, whomsoever gets into a manhole will be stripped naked and beaten up, lynched, actually, probably with the satay, they say, in the horse and all you use. I don't know what do you call in English. We use that and we'll beat them up. See, the problem for them is not the person who gets them into the work. They found this community has a problem. And even now they say if drinking is alcohol is a problem of my habit, it is not my habit. It is a social imposition of that. There's a history of how alcohol entered, like Malcolm X says, that is a fact in India also. Dalits, how they became so addicted for alcohol is because of the social problem. Okay. I told them, see, there is a septic tank business here. You are going and collecting garbage every day in your house, in each and every house, and you get just 400 rupees per month. 400, not 400 per day you get. Some 12,000, 10,000 you get, and you have been fighting with the government to get a government job. I'm saying that why don't you do this as a business? Because you're already going and cleaning the toilet at night time manually. Why don't you do a minimum investment you do, and you do it daytime also, nighttime, daytime, anytime you do. A minimum income of a septic tank cleaner in a hilly area like Nilgiris is 1.5 lakhs or 3 lakhs. So I said, well, you can earn like anything because you have been doing this work. Manually you did. Now, they said one word, brother, the one word that shocked me a lot. They said, they will
Guys,
brand a cleaner.
so sorry to interrupt. We'll just have to finish. Maybe you can conclude this in 1 minute and we'll move
So
forward.
they said that we will be brand as a septic tank cleaner. Then I said, branding is fine. Whether they brand you or not, caste does not go, but you get good money, you can educate and you can develop from that. Economy is something very important. They said no. Therefore, I resigned from my work. I was doing a self-respect trade union. And then I myself started doing this septic tank cleaning business. Right now, I'm doing septic tank cleaning. So what I want to say is, two people's articles were referred in Supreme Court. They both are no more in academics. Three people, Dalit Murasu, which article which I wrote, that Murasu, they wrote an article on the particular incident. After that, they were dead. And Gujarat NGO, Navasarjan wrote an finding about that. After that, they are not there. Actually, I don't know why many people call discussions. They should have called that Gujarat person also. He's no more, he's nowhere in the picture. So therefore, this is what is happening. So constitutional is something very different, but in social level, enormous caste discrimination. I can't say how much.
Thank you, Raisbhai. I think there is a lot to say, and we don't have much time. We have to finish in next 4 or 5 minutes. We have already taken around 90 minutes of your time, so I'll try to conclude. I hope there are no further questions. I would also request Arvind, Ashna, and Rais.
Just one question, Naveen bhai. Like I am
Okay.
Khalilur Rahman. Like I had one question. Like Arvind also spoke about the notion of untouchability differs, and also the question of law with the like the Supreme Court had was whether the scheduled caste community is a heterogeneous community or not. If it is a heterogeneous community, subclassification is permissible. It indeed said subclassification is permissible because Dalits are not heterogeneous, are not homogeneous. So, if that is the case, whether the benefit of this judgment should be extended to the Dalit Muslims, because indeed the 1950 order bars them from the reservation benefits. So, this is my simple, short, pointed question.
Do you want me to give a simple, short, pointed response, Naveen? 10, 20 seconds?
I would love to have 1 minute, but we only have 20 seconds. Let's take it to 1 minute if you can. It's okay.
Very, Raman, just a simple answer to that question is what the Supreme Court has put in place is certain kind of a mechanism, right? So, can you classify? Yes, you can. As far as 14 is concerned, 15 and 16 is concerned, right? So, the only, if you can demonstrate, right, as far as Dalit Muslims are concerned, there's an intelligible difference between Dalit Muslims and other Dalits. If you can demonstrate an objective for which the classification is to be done, then classification could be permissible using the logic of the Supreme Court. So you're right that route could possibly be opened out. But one more quick point on that: the Supreme Court also says subclassification is permissible, but micro classification is not. Right. So you have to be also conscious of the fact that micro classification is when there's no intelligible difference. For example, we're classifying and saying that all people entitled to reservation or retired by such and such a date. That may not be an intelligible differential, right? So there's a ways Dalit Muslim could potentially be an intelligible differential. That's again depends going back to the question of what we're discussing, sociological data, empirical evidence, all of us can go to making that particular case. It's possible.
Can I just add that the extension, I think, I don't know how it's connected to the idea of heterogeneity, but I mean that presidential order that came, it sort of again it theologized the idea of scheduled caste, and it really needs to be questioned as to why that happened. Because if we read Ambedkar's speech, "What Way Emancipation," he actually says that no matter what religion you may convert to, your political benefits, basically reservations that you will have, will not go away. Because that was a question that the audience or the people at that time had, and for him it seemed absurd that the idea of untouchability should be rooted in one particular religion only. So I think there's a lot to be researched over there as to why this differentiation between Hindu Dalits and non-Hindu Dalits, or Hindu and Buddhist Dalits and non-Hindu and non-Buddhist Dalits, has been made.
Oh, okay. I think we don't have much time. Thank you, Ashna, because there is plethora of work, research to be done, and a lot of discussion in our mind. And always these things, when they come up, they ignite us, and we just want to, kind of talk about this. No doubt. We don't have much time right now. Father, your mic, you have unmuted your mic. You want to speak?
I am muted. I don't have any questions that need clarification, but I just want to pose a question because this I really appreciate you, Naveen, as a moderator, and also the panelists and all the organizers for this very, very important critical issue for our discussion. And I wish and hope this is further taken up for a deeper discussion. And in this respect, my thinking is now this Supreme Court judgment raise in us or in me three major questions. is this issue a constitutional question relating to social justice in the preamble and in the Human Rights Charter? A social justice question coming as it is now after 75 years is rather late actually, but definitely it has come up. This question as a constitutional question has come up from the as Reis Mohammed has very well empirically shared with us from the grassroots level. Arundhati is in Tamil Nadu, state where I come from, and with Arundhati I have been closely associated also in Dalit questions. So it's really, is it a constitutional question that we need to reflect further, and therefore should we accept or not accept this question? Number two is it a political question? As it is now in Tamil Nadu, for example, we have the PL community, Pallar community, and PR Parayar community have taken up this issue, and Arundhati communities also have taken up the issue for and against. So, in terms of that, it divides the community. So far, we had that impression that we are of a homogeneous community, and this Supreme Court judgment has exposed, so to say, suddenly exposed that we are not that much homogeneous, but we are heterogeneous. And there is a lot of contradictions among us at the base level, and therefore it has become a political question, not so much of a constitutional justice question, but a political question which need to be addressed. Whether this is political question is good or bad, or whether this debate is good or bad, for us to be able to bring up once again to make us into a homogeneous community, this question also needs to be addressed. Its advantages, disadvantages, its positive and negative connotations. And thirdly, is it only a sociological question? Simply a sociological question with regard to a caste issue which needs to be annihilated, as Ambedkar has brought out in his book, which is only a sociological question. I think these questions need to be addressed in terms of really discussed in depth. I think from that point of view, I think this session, I think it has been a very good starter. I wish and hope that we be able to take it up in the future. This is what an observation that comes to my mind at the end of this program. Thank you very much. Thank you very much, and panelists also, and the moderator also, and the organizer also. Thank you.
Thank you, Father Ram. I'm also surprised at the number of participants today, very low. Nazar generally has more than 70 to 100 people. So I'm sure they might be enjoying their Sunday evening like us, but we are enjoying in our own ways, I guess. So let's kind of surprise. I'm sorry, Chaitanya, I cannot take the follow-up thing because we don't have much time now. And I think let's kind of conclude this and then move forward with how, we need to relook at this thing. And of course, like there are three more impugned legislations from Punjab, Haryana, and Tamil Nadu, which have, to some extent led to this constitutional bench judgment. They'll also be taken up for the hearing in the upcoming. So let's see how the Supreme Court kind of moves forward on this, and what specific ideology, what specific strategy they apply to this thing. And of course, one thing which we have not talked about is the caste censure, because we also must remember that approval for subcategorization itself is based on empirical data, which Arvind very specifically has talked about. And as such, it would also require a comprehensive caste census. And because without that, there won't be any realistic basis to assess the degree of relative deprivation. And that is, of course, the need of the hour, and that is more we need to kind of discuss around that. And in conclusion, while the judgment on subclassification, which we were discussing, opens the doors to very, very, very important reforms, thanks to Rais, thanks to Fadrullah, thanks to Arvind and Ashna, who have very beautifully kind of summarized and initiated this discussion. And we have already started moving forward to these reforms, and we must also ensure that it does not lead to any further divisions amongst already marginalized community. And how do we do that? that is something which need to be, kind of decided by the state, by the judiciary, and by civil society organizations like I'll just try to summarize this is in Hindi. So हालांकि हम इस चीज़ में काफ़ी देर से चर्चा कर रहे हैं, और जो भी निर्णय आया था सुप्रीम कोर्ट द्वारा, सब क्लासिफिकेशन की बात कर रहे हैं, उप वर्गीकरण की बात कर रहे हैं कि दलितों में और कौन से समुदाय हैं जिनको इस तरीके का भेदभाव झेलना पड़ता है। लेकिन उसके लिए हमें एक जातिगत सर सेंसस की जब हम बात करते हैं तो वो उसकी भी एक ज़रूरत है, उसको लेकर हम आगे कैसे जाएंगे। और साथ में जो अलग अलग नज़रिए पेश हुए हैं, चाहे वो रईस के द्वारा हो, चाहे वो आशना के द्वारा हो, चाहे वो अरविंद ने बहुत स्पष्ट रूप से बोला है उस चीज़ को लेकर, तो वो हम इस चर्चा को और आगे ले जाएंगे। और आशा करते हैं और साथी हमारे अगली बार जुड़ेंगे। इस बार तो हम सिर्फ शुरू हम 35 तक थे, बट अभी आधे पे आ गए। लेकिन कोशिश करते हैं आगे और साथियों को लेकर आएंगे। और साथ में एक चीज़ और आपको मैं जानकारी देना चाहूँगा कि वो नज़र जो है ऐसे ही डिस्कशन को अब हर हफ्ते करने की कोशिश कर रहा है, ताकि हम अलग अलग तरीके से अलग अलग नज़रिए लेकर आए। सो विल हैव डिस्कशन ऑन दिस थिंग, ऑन दिस स्पेसिफिक टॉपिक every week, and next time we are trying to have a full women paneled advocates and social justice activists on this discussion on this specific issue. So let's see how do we take this forward. But all of you are welcome, and thank you very much, Arvind, for giving us time again, and Ashna and Raisbhai, we kind of request you to keep giving us time again and again for this, and let's see how the whole fight and journey of social justice move forward in coming days. Thank you everyone. Thank you.
Thank you.
Thank you.